Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Live Law, your one-step destination to all legal developments in the country. Let us start. A Delhi court today denied bail to former JNU scholar and activist Umar Khalid in connection with the Delhi riots larger conspiracy case registered under the Unlawful Activities Prevention Act. Additional Sessions Judge Sameer Bajpai of Karkarduma Courts dismissed the second regular bail plea filed by Khalid. This fresh bail plea was moved by him after he withdrew his plea seeking relief from the Supreme Court. There, Khalid had challenged the decision of the Delhi High Court denying him bail in October 2022. Khalid has been behind bars since September 2020, awaiting his trial under the UAPA for his alleged involvement in the larger conspiracy surrounding the communal violence that broke out in February 2020 in the national capital. Coming to the plea filed by Delhi Chief Minister Arvind Kejriwal to extend his interim bail for 7 days beyond 1st June, that is when it was to expire. As you are aware that the Aam Aadmi Party leader was arrested by the Enforcement Directorate in connection with the alleged Delhi liquor policy scam. Earlier this month, the top court had granted him interim bail to campaign for the Lok Sabha elections. As per the interim order, Kejriwal has to surrender on 2nd June. Kejriwal has now prayed for the interim bail to be extended so that medical tests, that is PET CT scan, prescribed by the doctors can be conducted. Senior advocate Dr. Abhishek Manu Singhvi mentioned the application today before the vacation bench comprising Justices J.K. Maheshwari and K.V. Vishwanathan. He requested the bench to list the application to be heard tomorrow. The bench stated that the matter was already heard and the judgment was reserved. However, Singhvi informed the court that the matter was heard relating to challenging the arrest by ED, but the instant application was filed on the medical grounds seeking an extension of the interim bail. The bench directed the memo to be listed before the Chief Justice of India for passing an appropriate order. The Jharkhand High Court today sought response of the Enforcement Directorate in a petition filed by former State Chief Minister Hemant Soren seeking regular bail in connection to a money laundering case related to a land scam. Last week, the Supreme Court had dismissed his petition challenging his arrest by ED in this money laundering case. In the fresh bail petition filed by Soren, it has been stated that ED does not possess a single document related to the 8.5 acres of land which it alleges he grabbed. Additionally, it was stated that land under Jharkhand's Chota Nagpur Tenancy Act cannot be transferred to anyone under any circumstances. Soren urged for an immediate hearing on the matter, which was scheduled before the bench of Justice Rangan Mukhopadhyay today. He pleaded before the court that his name does not figure in any of the documents related to the land in the bargain circle and argued that no offence under PMLA is made out against him. During the hearing today, the Enforcement Directorate requested the court for 3 to 4 weeks to file its response. However, Justice Mukhopadhyay granted 2 weeks and has scheduled the next hearing for 10th June. Stay tuned. The Delhi High Court today issued notice on the plea filed by Aam Aadmi Party leader Satendra Jain seeking default bail in the money laundering case. Justice Swarnakant Sharma sought response of the Enforcement Directorate and listed the matter for hearing next on 9th July. Jain, who is presently under judicial custody, has challenged a trial court order passed on 15th May dismissing his application seeking default bail under Section 167 Clause 2 of CRPC. This case relates back to Jain, who was arrested by ED in 2022 and revolves around allegations of money laundering through 4 companies during 2010, 2012 and 2015-2016. Jain sought default bail on the ground that ED failed to complete the investigation within the statutory period but filed a complaint under PMLA against him. The AAP leader contended that filing of an incomplete charge sheet or complaint in a PMLA case when investigation is pending is violative of the fundamental right of an accused under Article 21 of the Constitution. In March, the Apex Court had observed that Satendra Jain, along with his aides Ankush Jain and Vaibhav Jain, were prima facie guilty of the alleged offences of money laundering. This was when the Supreme Court refused to grant him bail. The Delhi High Court has dismissed a plea challenging the appointment of administrator of Delhi Waqf Board with cost of 10,000 rupees. The plea was moved by a resident of Mehrauli who was aggrieved by several actions taken by the administrator of the Delhi Waqf Board. He contended that his mother was buried in the graveyard adjacent to the historic Acquited Mosque, a property which he claimed was a property classified as a Waqf property with the Delhi Waqf Board. It was his case that some portion of the mosque was demolished under authority of the administrator, who should have protected it as custodian of the Delhi Waqf Board. The petitioner sought removal of the administrator, contending that he failed in his duty to protect a Waqf property. But the court rejected the plea and noted that the petitioner had filed a similar plea raising the same allegations, which was withdrawn before a coordinate bench. It added that other than stating that the actions of the administrator were bad, no reason was given as to how the official lacked in qualification to be appointed as an administrator. Justice Subramaniam Prasad said that the plea was an absolute abuse of the process of law without giving any valid reasons as to why the appointment should be quashed. Thus, the petition was dismissed with costs. And now let me tell you, the Punjab and Haryana High Court has acquitted Dera Sacha Sauda chief Gurmeet Rahim Singh in the Ranjit Singh murder case. A CBI court in Haryana's Panchkula had in 2021 sentenced him and 4 other accused to life imprisonment after they were convicted for hatching conspiracy to murder the former Dera manager Ranjit Singh. According to the CBI charge sheet, Ranjit Singh was shot dead in July 2002 because Rahim suspected that he was behind an anonymous letter which was circulated exposing cases of sexual exploitation of his female followers. The CBI court had concluded that it was proven beyond reasonable doubt that Rahim was upset by the letter's allegations of sexual exploitation and conspired with others to murder Ranjit Singh. Against this order, an appeal was preferred before the High Court. A division bench of Justice Sureshwar Thakur and Justice Lalit Batra has allowed this appeal against conviction and has acquitted him in this case. Rahim is currently serving a 20-year jail term for committing rape of 2 of his disciples. He is also convicted for murdering a journalist and has been awarded life sentence which will run after the end of this 20 years term. Recently, the Punjab and Haryana High Court had directed him to surrender and had asked Haryana government to not consider his case for grant of further parole without the permission of the High Court. The Meghalaya High Court has modified the murder conviction of a man who allegedly caused the death of ex-husband of his wife after discovering both of them in a compromising position in the bedroom. For better understanding, first let me tell you here about second exception to section 300 of Indian Penal Code. It states that if someone kills another person due to severe and immediate provocation that would cause a reasonable person to lose self-control, it is not considered murder but a less serious crime called culpable homicide not amounting to murder. This means that the punishment is less severe, typically ranging from a few years to life imprisonment rather than the death penalty or life imprisonment without parole that comes with a murder conviction. Essentially, this exception recognizes that extreme provocation can lead to impulsive actions, and the law provides a lighter punishment in such cases. In this particular case, the appellant discovered his wife in the company of her ex-husband in a compromising position inside her bedroom. Being enraged by such acts, he attacked the ex-husband with an axe and caused his death. After committing the offense, he voluntarily surrendered before the police and confessed his guilt. The investigation was carried out, and upon its completion, the charge sheet was filed against the appellant for commission of murder of the deceased, that is under section 302 of IPC. After hearing contentions of both parties, the division bench of Chief Justice S. Vaidyanathan and Justice W. Danglo termed the act of appellant as a reaction to safeguard his right over his wife without any premeditation or intention. The bench observed that in a sacred relationship, the husband is the property of the wife and vice versa. And if one betrays the other, this type of incident will take place due to sudden provocation or emotion. It was held that the appellant committed the act under grave and sudden provocation. Considering all the surrounding circumstances, the court was of the opinion that the act of the appellant falls under exception 2 to section 300 and thus he was held guilty of culpable homicide not amounting to murder instead of the offence of murder. Accordingly, he is to undergo rigorous imprisonment for 3 years. And lastly, a Delhi court today summoned Delhi government minister Atishi Marlena in the defamation case filed by BJP leader Praveen Shankar Kapoor over the claims that Aam Aadmi Party leaders were approached by the BJP to join them in return of crores of cash. Kapoor is aggrieved by Aam Aadmi Party's claim that BJP is trying to poach its leaders every time they are approached by the Enforcement Directorate. Kapoor has said that the allegations were false and unsubstantiated and that AAP leaders furnished no material to support their claims. Chief Metropolitan Magistrate Tanya Bamyal of Rouse Avenue Courts has directed Atishi to appear in court on 29th June. However, the court has not issued summons to Chief Minister Arvind Kejriwal, another accused against whom the criminal defamation case has been filed. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.